Welcome to this final webinar in our series on the Bribery Act. Today we explore international and comparative perspectives on anti-bribery efforts. I am Dr. Colin King, Director of the Centre for Financial Law, Regulation and Compliance, or FinReg for short. And a key focus of our work in FinReg is to bring people together from different backgrounds as well as from different countries in the area of financial law and regulation. And today's webinar certainly fits that bill. We have fascinating insights from different areas of law and regulation and from different countries. And I'm really looking forward to this webinar. Our speakers will talk for between 15 and 20 minutes each. Then we will open it up to questions and answers. And as always, please put your questions into the chat box and we will put those to the speakers at the end. Our first speaker then is Lilith Nagapetian, who is a qualified lawyer, a chartered accountant and a certified fraud examiner who is currently practicing with a forensic accounting firm, Smith & Williamson in London. In her practice, Lilith focuses on commercial disputes and damages in both litigation and arbitration. And she has also been involved in a number of international fraud and financial crime investigations. In parallel, Lilith is a doctoral candidate at the School of International Arbitration at Queen Mary University. And the focus of her PhD research is corruption in international arbitration, as part of which Lilith explores the impact of extraterritorial application of the UK Bribery Act on arbitration proceedings. Lilith, we pass over to you.
Thank you very much, Colin, and good evening, everyone. Many thanks for joining today's webinar dedicated to the international and comparative aspects of anti-bribery. Very glad to take part in today's discussion, and many thanks to you, Colin, for organizing this event, despite all the challenges that prevented this event from being held offline. I'm also delighted to share the floor today with Horace, Khaled, and Luana, and I'm looking forward to an interesting discussion. And as Colin said, if there are any questions about my presentations, please leave your questions in the chat and I'll be addressing them at the end. I will now share my presentation with you. Okay, so yes. I think we're gonna look at the slides in this format because for some reason they're coming up on the screen. So today I'm going to talk about, I will kick off our discussion about the international and comparative perspectives of anti-bribery with the discussion of the impact of the UK Bribery Act on the international arbitration and the interplay between the regulation which was introduced by the Act and the international arbitration, which is a private form of international dispute resolution, which emanates from the agreement of the parties and is regulated and enforced by the state. So in an international arbitration, a number of systems of law may simultaneously apply, which can be different from one another. And therefore, the choice of law complexities inevitably arise in determination of the substantive and procedural law, which is applicable to the merits and to the proceedings of the dispute. Therefore, arbitral tribunals, they do have the flexibility to determine and to apply the most appropriate standards for a particular dispute, having regard both for the applicable law and the facts of the case. However, they should be conscious of the need to apply the law which complies with their duty under the most sets of arbitration rules to seek and to render an enforceable award. Now, in international arbitration, the trend has moved towards no or zero tolerance of corruption, which arbitrators have become compelled to address. When it comes to the allegations of bribery and corruption in international arbitration, determining which laws arbitrators should apply can be outcome determinative. And that was, for example, the case with the World Duty Free against the Republic of Kenya, the flagship corruption case in arbitration, where the tribunal applied a domestic law and found the underlying contract unenforceable by virtue of English and Kenyan laws. Now, the UK Bribery Act has incorporated obligations upon state parties that have an extra-jurisdictional reach up to a certain extent. This implies that arbitrators may need to take into account the criminal offences that have been stated under such legislation. And arbitrators, therefore, should be aware of the Bribery Act, even where the governing law is not English law, or where the place of the performance is outside of the UK, or where the parties are not based or are not incorporated in the UK, because the Bribery Act may still be relevant by virtue of its broad jurisdictional application. And therefore, the arbitration practitioners, they need to take into account of a number of ways that the UK Bribery Act can have an impact on the arbitral proceedings. Well, first of all, as I just mentioned, is an international ambit, which is not restricted to UK nationals, and therefore Bribery Act can apply to arbitration disputes involving business relations and transactions, even if the company is not present in the UK. Therefore, when the arbitrators are making the choice of law decisions, they need to take that into account, whether the UK Bribery Act applies or not. Now, secondly, whilst arbitrators need to be on the lookout for indications of corruption, the meaning of corruption, of course, differs under the national legislation. So there are subtle or more significant differences between the leading national and international legal regimes to the type of conduct which constitutes corruption. And the UK Bribery Act, of course, placed into stark relief differences between jurisdictions. For example, it prohibited the private bribery, which is the bribery of private businesses and individuals outside of the UK. Therefore, when arbitrators, again, are on the lookout for any potential red flags that would indicate corruption, they shouldn't only just focus on the corruption of public officials, but this also impacts commercial arbitration as well, which is a much more subtle area for arbitrators to consider because of the difficulty of uncovering corrupt acts in contracts and in commercial disputes. Now, once the law has been chosen and the arbitrators have established which law applies to the disputes, now they have to decide on the admissibility of the claims, which are potentially tainted with corruption, and on the burden of proof. Now, the tribunals can draw inspiration from national best practices, including the UK Bribery Act, because the Act has reversed the burden of proof. It has established an offence for failure to prevent bribery for companies, including parent companies. And the Bribery Act has introduced an adequate procedures defence that the majority of people are aware about. But for instance, what is the implication then for the arbitration process? The arbitrators can potentially make inferences from the application and adoption of adequate procedures by both companies, but also the states, because the states they have assumed obligations under international treaties to adopt and maintain control measures over their own officials and to prosecute violations. And therefore, the tribunals can approach the issues by building a consensus in the arbitral community on what are the expected adequate procedures of states and investors when it comes to bribery, corruption, and economic crimes, and whether they can also make inferences, whether adverse or positive inferences from the state's conduct where the issue of corruption is involved in arbitration. Furthermore, as compliance programs also become more mainstream with the adoption of the UK Bribery Act, arbitral tribunals can also inquire into companies' own preventive measures, which are relevant to the specific case and to the contract before them, and also make inferences regarding the adequacy of the company's efforts to manage those corruption risks. Therefore, when arbitral tribunals, they take a proportionality approach where the conduct of the parties, they do influence the outcome of the case, for example, in the allocation of damages or in the question of restitution in cases of corruption. They might make those responsibility or attribution decisions based on those findings. In addition, as an impact of the introduction of the UK Bribery Act, we have seen a growing use of covenants and representations and warranties in commercial contracts that do specifically refer to the UK Bribery Act, even if the place of the performance of the contract is not on the territory of the United Kingdom. And the assertion of those anti-bribery terms in commercial contracts as a clause, which state that, for example, neither corporate or employees have ever made, offered or promised any payment or gifts that contravene the UK Bribery Act, is intended to set up that possible defense in an arbitral process, that it had in place those adequate procedures, and therefore the outcome of the dispute should take into consideration those the conduct of the parties. Now that's with the reversed burden of proof. Now there's also a question of the standard of proof, which is traditionally a very problematic area for the issue of corruption in arbitration, because currently there is no established approach which exists for the standard of proof that would apply to corruption allegations in international arbitral disputes. So in arbitral proceedings, mere red flags or circumstantial evidence are often not sufficient to establish the defense of corruption for example, non-payment of fees to an agent or a consultant. And this is because in those types of cases, the laws of civil law countries often govern the contracts. The seat of arbitration is outside of the UK, and the arbitrators themselves, they also come from the civil law jurisdictions. And in those circumstances, the governing law will require actual proof of corruption by clear evidence. Some arbitrations, however, have held that rumors and innuendos, as they call it, will not fulfill that requirement. And even though a higher standard of proof might be required for bribery allegations, they, however, do not coincide on the degree of the stringent approach that need to be taken in those cases. And this is because of the number of factors: the seriousness of allegations, the inherent improbability and the potential for the criminal sanctions. For example, the party might be deprived of the entire benefit that they have derived under the contract and also of the whole amount of the bribe. The problem is that institutional rules as well, institutional rules of arbitration, do not contain clear definition of or guidelines on the standard of how a tribunal should examine evidence of corruption. Now, the UK Bribery Act imposed the standard of proof for criminal sanctions beyond a reasonable doubt. And it did not change the standard of proof for civil cases, which are applicable in arbitration, which is proof on the balance of probabilities. Now, this might present a challenge for the arbitrators when, for example, the bribery isn't a crime under the applicable law. Imagine if the English law does not apply directly, so the applicable law is a domestic law of a different jurisdiction. And where the bribery is not a crime, the UK Bribery Act applies because of its extraterritorial effect. And now for arbitrators, it is not clear whether the red flags methodology and circumstantial evidence shall be deemed sufficient for establishing corruption or not. And there have been a number of arbitral decisions which were contradictory and which arrived at different conclusions. For example, to date, the problem of confidentiality in arbitration also contributes to this problem, because the majority of the published decisions nowadays are investor-state arbitrations, where the states raise corruption allegations as a defense against investors' claim. So historically, investment arbitration tribunals also follow the same approach as is established under the UK Bribery Act, that the serious nature and severe consequences of finding of corruption, they imply that investors should be deprived of any treaty protections, and therefore this needs higher, clear and convincing evidence. The case of World Duty Free or the Fraport case. However, in commercial arbitration, and especially in the cases where the corruption allegations are raised not by a state, but by private individuals, whether in private bribery cases or in investor disputes where the corruption allegation is raised by a private party, like it was in the EDF against Romania case, the involvement of those government officials in corruption in investment cases is potentially one of the flaws where it is impossible to find it to establish clear and convincing evidence. That's investor cases. And in private bribery cases, it's also sometimes impossible for one of the party, because of the confidentiality reasons, to get access to this evidence that would establish clear and convincing evidence standard of corruption. Therefore, these challenges have prompted tribunals recently towards a more pragmatic approach, a more flexible approach, like it was in 2013 in Metaltech against Uzbekistan, another flagship corruption case in arbitration. And the tribunal there stated that corruption can be shown through circumstantial evidence, and therefore a red flag analysis of indicators of corruption is possible. And in Nico Resources case, the tribunal echoed those considerations, and they said that even though a high standard of proof is required, or a high degree of confidence of a tribunal is required to establish evidence of corruption, this does not mean that the standard of proof need to be necessarily higher. Now, nowadays, there's no consensus yet as to the standard of proof that can be applied in corruption cases in arbitration, especially where the UK Bribery Act applies and where it is in conflict with applicable law. And this might present a challenge for the arbitrators in those disputes. Another aspect of the impact of the UK Bribery Act on the arbitral process is the issue of the staying of the proceedings. Now, the famous Siemens case back in 2007, the Siemens arbitration case raised the question whether arbitral tribunals should consider staying arbitration if there is a parallel criminal investigation ongoing in the respondent's home country. Now, the issue here is different between litigation and arbitration. Because, for example, it's true that in many civil law countries, civil proceedings are stayed while the resolution of the criminal matters is ongoing. However, this rule is not applicable to international arbitration. For example, in France, French Code of Criminal Procedure, it allows staying of civil cases pending the resolution of criminal matters. However, this does not apply to parallel arbitration proceedings. So in case where there is an ongoing arbitration case involving a matter of corruption, and there is an ongoing investigation under the UK Bribery Act in the state of residence of the respondent, how should arbitral tribunals react to this? Should they stay arbitration or not? This staying arbitration would prevent situations in which arbitral awards are later called into question. Because if arbitral tribunals do not stay their proceedings, it might lead to a situation, as it was with the Siemens award, where the Siemens award was waived because of the parallel criminal investigation was resolved in the respondent's home country. However, in 2012, a more recent case, there was a similar case where an arbitration was brought in Switzerland under Swiss law, and the respondent company sought a stay on the basis that it would expose itself for criminal liability under the UK Bribery Act, because criminal investigations had been initiated by that time already by the UK Serious Fraud Office, and concerning potential number of corrupt projects in which the consultant had participated. Interestingly, in that case, the tribunal refused to stay the proceedings because it emphasized that it was unclear when the criminal investigations would conclude. And therefore, the interest in obtaining an arbitral award outweighs the interest of a party in suspending its contractual obligations and the termination of an investigation, which has an unknown date of completion. Therefore, arbitrators might seek and keep the criminal investigation separate and independent from the arbitral proceedings. But at the same time, it does pose a threat as to enforceability of the award they render and the risk that it might be later be waived, depending on the outcome of the criminal proceedings. Last but not least, the reporting obligation of the arbitral tribunals also comes to mind and comes into focus when in the area of interplay between the UK Bribery Act and international arbitration. Now, arbitral tribunals need to bear in mind that there may be circumstances where reporting obligations can be triggered. If this is to occur, so it might lead to an examination of the applicable laws as to the confidentiality and as to their reporting obligations. Unfortunately, the UK Bribery Act does not include any indication or any rule which regard an obligation to report corruption to relevant authorities, and even if there was an obligation to indicate which authorities the act needed to be reported to. And this lacuna currently does present a number of challenges because of the jurisdictional issues. Because if the dispute does not take place in the territory of the UK, and if the applicable law is not English, however, the UK Bribery Act applies, the arbitrators might find themselves in a position where they need to report the matter of corruption that was raised in the arbitral proceedings, but it would be unclear whom to. And there have been cases where they would report it, for example, to the Serious Fraud Office in the UK, and they would refuse to take any actions based on the jurisdictional issues. And finally, when the tribunals do reach positive findings of corruption, it is often assumed that the consequences are that the commercial transactions are void. This is not entirely correct for all jurisdictions, and it would depend on the nature of the case, the criminal or civil consequences. It might seem that the UK Bribery Act simply concerns criminal law. In theory, should be relevant for civil claims. However, the impact of the Bribery Act does extend beyond just the criminal law. There was a decision by the UK Supreme Court which referred to UK Bribery Act as creating an expectation of the law to be stringent in cases where an agent has received a bribe or commission. So the pronouncement by the UK Supreme Court is not only an endorsement of the wider policy considerations concerning universal prohibition of corruption, but also signals the relevance of the UK Bribery Act in the civil context as well. So when deciding the remedies, the arbitrators need not only to take into account the UK Bribery Act in the qualification of bribery as a criminal act, but also in deciding the civil consequences of corruption. So overall, this is a roadmap of issues that an arbitral tribunal may need to consider as a result of allegations of corruption. And for majority of those issues, there is no established universal consensus yet. And that's why the outcome varies between different arbitration cases, and only on some of them, like standard or burden of proof, can be said that there is an emerging transnational response. However, it will still require more time for any established practice to be formed in this area. Thank you very much, and I would expect any questions from the audience to be addressed at the end.
Thank you very much for that. That was a really fascinating presentation. Our second speaker is Dr. Khalid Al-Rashidi, who is Assistant Professor in Criminal Law at Kuwait University. He holds his LLM in Criminal Law and Criminology from the University of Leeds. And earlier this year, 2020, he also got his PhD from Leeds, which was a socio-legal study of corruption in Kuwait. And Khalid was also awarded a prize for outstanding academic performance by the University of Leeds. And before engaging in academia, he worked for 5 years as a state lawyer in the administrative courts. And Khalid is currently finalising a book to be published in March next year on combating corruption in the Middle East. Thanks for joining us today. Khalid, over to you.
Thank you, Dr. Cullen, for having me today. I will start sharing my presentation today. Thank you in advance for listening to me. Today I will talk about modernizing bribery law in Kuwait, and that includes 4 issues. the contours of the corruption problem in Kuwait, the current bribery law in Kuwait, the effectiveness of current law against grant corruption, and the final issue is modernizing the Kuwaiti bribery law with a reference to the UK Bribery Act. In a region of the GCC, and especially in countries rich in natural resources like Kuwait, one cannot talk about the bribery law before delving into the phenomenon of corruption, exploring its nature in this exact area. I will talk in a brief about the phenomenon of corruption in Kuwait based on my recent research, including a book that will be published or accepted for publication by Routledge next year, which was originally my PhD thesis. I will only start with an important area of research in the corruption literature, which is about corruption patterns. Corruption has been classified into numerous patterns, and what matters much in our case is the public grant corruption. Grant corruption is about political corruption. It involves high-level public officials in a given state, and this includes what is known as state capture, which is when the state official decision-making is affected by private interests from the private sector. I found that this type of corruption is prevalent in Kuwait, and this is mainly because of the characteristics of Kuwait as a state. For example, and most importantly, the government-dominated oil-based economy structure of Kuwait is said to trigger the grant corruption as the prevailing corruption pattern, and this is based on specific mechanism that is outside the scope of our seminar. But how is this relevant to our topic today? On the one hand, the government-dominated economy in Kuwait leads the public sector to dominate, dwarfing the private sector, and on the other hand, the massive oil revenues create an enormous state budget, making this budget one of the most important, if not the only, source of public expenditures. The focus then will naturally become on the state budget. Public funds becomes more alluring, especially for the private sector. As one politician I interviewed while writing my PhD pointed out, private sector in Kuwait is to a large extent dependent on the public sector in gaining wealth. And this becomes starker when we know that the weak private sector in Kuwait is deprived of its power as a pressure group, making them more parasites than anything else. Returning to our topic about bribery, private sector and actors in this atmosphere of rent-seeking are expected to have an instigating role in the bribery cases. The dependence of a private sector on public sector will increase the possibility that private sector will resort to illegal means, for example, to win contracts with the government, and these illegal means include bribery. However, this doesn't negate the fact that there are some other legitimate means by which the wealth can be transferred to individuals and corporations from private sector based on specific socio-political dynamics stemming from the Kuwaiti social organization. So, what about the current bribery law in Kuwait? That was an introduction, that was a necessary introduction to understand how corruption takes place in Kuwait. Now we are talking about the current bribery law in Kuwait. The bribery offense is one of the earliest responses to corruption in Kuwait. They were first criminalized in 1960 by the Criminal Law Act, and after 10 years later, bribery offenses were reviewed and amended by Criminal Law Act 1970, which introduced harsher penalties for bribery offenses and aimed to counter the proliferation of bribery at that time and the threats it posed to the state apparatus. The current law contains a number of traditional forms of bribery, ranging from active, passive bribery to influence peddling or trade of influence crime. While these bribery forms may differ in some details, they all have one thing in common. They only apply if a public official is implicated in the bribery transaction. Therefore, bribery that entirely occurs within the private sector, which is private to private, is not a crime in Kuwait. Without going into the details of these offenses, the bribed offender in all cases should be an official. And in our webinar, we can take the doctrinal analysis away to reach our conclusion. So we can readily reach to our conclusion without even analyzing the current law. So the law mainly focuses on the integrity of public sector, and to that end, the law extends the meaning of the office holders beyond the concept of the officials in the administrative laws. And these measures reflect the key concerns of the bribery law in Kuwait, as the law itself stated, that the rationale beyond the criminalizing bribery is just to protect the public office and to maintain the trust in it. But does the current bribery law in general serve the purpose that is or that it has been legislated for? And this is the third issues that we will discuss now. Based on my recent research on this area, experts emphasized that the current law on bribery aims to criminalize a wide range of potential abuses of the public office. And the current law also sends a message to officials that bribery is unacceptable, that to the extent that it's criminal just thinking about engaging in bribery, and even if the official does not have the capacity to do what he or she promised. And also the ability to apply bribery to many potential cases has led some professionals to think that bribery as a legal text is effective. So it's not surprising then that one expert stated that based on their relatively high rate of referrals by the public prosecutors and convictions by the courts, bribery is more effective than other corruption crimes. Also, a judge has concluded that since its criminalization, there have been numerous bribery cases and that have ended with convictions. Anyway, despite this endorsement by the experts, the bribery offense has been beset with many practical problems and criticized by Kuwaiti professionals. Across the interviews conducted, the problem of difficulty with the proving bribery could be inferred as an emerging pattern. Perhaps this is a practical issue that has serious implication in reality, but my talk today is more on or is more about conceptual issues. It aims to reconsider ideas lying beneath the bribery law in Kuwait and whether the current law is effective against broad corruption. So our topic, or my talk today, is more conceptual than trying to explore practical problems. Actually, I can say that, in fact, the ground upon which the Kuwaiti bribery law is based could be characterized as consistent with the pattern of corruption that is prevalent in Kuwait, which is grand corruption. The law explicitly aims to protect the integrity of public sector as the largest and most important, at least financially speaking. And this theoretically is good and illustrates the fact that the law is directed at the right target. So if someone asks, does the bribery law in Kuwait needs to be modernized? The answer is simply yes. And if someone asks about any previous attempts in this regard, the answer is also yes. There has been a long debate among Kuwaiti practitioners and academics about the need to criminalize private bribery. It can be said that almost all papers that were written about bribery in Kuwait ended with conclusions and recommendations to introduce the offense of a private sector bribery. And I think I should start with these attempts before putting forward my argument today. Reforms that revolve around the criminalization of bribery of a private sector are counterfactual. I mean, they problematize what is not in reality, but by assuming that the corrupt relationship between individuals and corporations are the central to the problem of bribery in Kuwait. And this is not very precise. Private to private bribery may have deleterious impact on the market, but in an economy where the public sector has the hegemony, the real problem becomes public to private, not to private to private. And thus, these proposed reforms, I mean, criminalizing private sector bribery, may not proceed from factual information. Furthermore, criminalizing bribery that occurs wholly within the private sector necessitate a transformation in how the Kuwaiti policymakers perceive bribery. For example, Peter Aldridge stressed that the changes in the bribery law in the UK are based on the assumption that the UKBA gave up the idea that the essence of a bribery is that it's an offense of disloyalty, and embraced the idea that the bribery undermines the proper operation of markets. So in Kuwait, we perceive bribery to be disloyalty, to this kind of a protection of a public sector rather than, as Aldridge said, proper operation of markets. However, this is not an attempt to downplay the adverse consequences of private bribery. What I'm trying to say is that the large dependence on the public sector in Kuwait casts doubts on the exigency of criminalizing private bribery, at least for the time being. So it's too early to call for the criminalization of private sector bribery, and efforts should be saved for reforms of higher priority. My suggested reform here is to modernize the current law. It is about paying more attention to the instigating role of the private sector. Although the current law criminalizes the non-office holder parties, bribers, with harsh penalties, there is still much more to do in this respect. The policymakers' search for effective bribery law must begin with the potential role played by the private sector, especially cooperation in the public-private relationships, especially when seen with the economic context of Kuwait, in which the public sector represents the key source of wealth. Indeed, this potential role indeed, this potential role of the private sector is what has been considered by Nazaha in this strategy or on the counter-corruption strategy in 2019 to 2024. To that end, a good lesson a good lesson can be drawn from the UK experience in this context. The House of Lords Select Committee on the Bribery Act described the act as an example to other countries, especially developing countries, of what is needed to deter bribery. In the Bribery Act 2010, a new bribery crime has been introduced, which is failure of commercial organization to prevent bribery. This crime established the criminal liability of corporation in bribery cases whenever a person associated with that corporation bribes another, and is defense for the corporation if it proves that it had in place adequate procedures designed to prevent a person associated with it from undertaking such conduct. And this is a very known crime that maybe most of you know about. This bespoke, innovative corporate offense has a distinct function in Kuwait in many respects, and I will try to talk more faster so that I can finish my talk today. First is to establish an innovative corporate criminal liability where the liability is not derivative. It's directly derived from its organizational liability based on the organizational fault model. I'm currently writing a paper which will be published soon about the reality of criminal liability of corporation in Kuwait, and I can say that I found the legal developments in this regard rather fragmented and piecemeal, and there is no general rule or framework for the corporate criminal liability in Kuwait. Besides the fact that corporations originally cannot be held criminally liable in bribery cases because of the lack of provisions in that matter. Second, the UK example can or will shift the focus from retribution to deterrence. I mean the purpose of the criminal law itself. And this has a proactive function. It prevents the bribery of public officials by dealing first with the potential criminality coming from private sector. And this can be done through inducing the private sector to comply with the law by establishing internal systems that aim to prevent bribery practices. My argument is that corporations are deterred from action when they refrain from those. Corporations are deterred from action when they refrain from those actions due to aversion to the possible consequences of the action. And this, as I think, may have a huge impact on creating a healthier environment. Moreover, when corporations are encouraged to give or to have in place integrated system to avoid criminal conviction, the reputational value of lawful behaviors will be increased. So corporations, however small or large, then will try their best to put in place proper controls. I would conclude with these facts or assumptions. The legislative history of bribery law in Kuwait and its philosophy can be said to be directed at the real problem. And we have a bribery law that is punitive and widely applicable. But any future reforms to modernize the existing law should first focus on the criminalities stemming from private sector, as I mentioned in my presentation. However, some questions remain whether the forms or the current forms of illegal exchange taking place today in Kuwait take the shape of a bribery as it is typically known. I would doubt that because given the current social organization in Kuwait, which is collective and is based on kinship. Exchange of benefits goes beyond explicit bribery. Sometimes even without being asked, a high-ranking official gives an undue advantage to his close relative who has a business with the employer of that official. And in this context, Conflict of Interest Act was enacted in 2018 to list cases in which conflict of interest may arise. That act was of a criminal nature, as it, for example, criminalized the failure to disclose some cases of conflict of interest that result in harmful outcomes. So conflict of interest was described by one expert that it is a modernized form of bribery, and the criminalization of conflict rectifies some drawbacks that bribery law is plagued with. Thank you very much.
Liz, thanks very much for that, and it certainly whets the appetite for your book coming out in the new year, and I'm looking forward to reading that. Our third speaker is Luana Mataya Suto, who is a legal advisor in the Federal Prosecutor's Office of the state of Minas Gerais in Brazil. And until September of this year, she practiced as a compliance lawyer. Luana holds a master's degree in public law, and she is currently a law PhD student at Pontificia Universidade Católica de Minas Gerais, and Luana's PhD studies are financed by Kate. Luana, thanks for joining us today. Over to you.
Thank you. I will share my presentation to all of you. Okay. Before to start my presentation, I want to say thank you so much, Professor Dr. Colin King, for organizing these webinars. I am very glad to be here today. It is an honor to be here with so prestigious colleagues. And I am also happy to be in England, even that is in a virtual way, because I have good memories from this country. When I finished my law degree, I went to England to study English in Newcastle upon Tyne, and I was very welcome there. So England is always in my mind and my heart. So I am very happy to return, even that is from my own home. So to this webinar, I prepared a presentation that I want to talk about how the UK BRIP Act and the other foreign anti-bribery legislations impact in Brazilian reality, and how this starts the car wash operation, the major anti-corruption investigation in Brazil. In Portuguese, this operation is called Lava Jato, and I personally can say that this operation changed and normalized the Brazilian reality, and its effects can be felt until today. So in 2030, during Dilma Rousseff's presidency, was edited Brazilian anti-corruption law. It is the legislation based on UK BRIP Act and the American FCPA. The Brazilian law have the same effects that the others, the extraterritoriality effects, and the UK BRIP Act was published in 2010, and the Brazilian law was made 3 years later. So this Brazilian legislation changed our juridical reality because it introduced the possibility that the private or public companies, legal entities in general, could suffer sanctions, legal sanctions for corruption, bribery, fraud that your CEOs, the board, or other members do inside or outside of Brazil. Before this legislation, only a person that do bribery, fraud, or corruption was liable, and the legal entities wasn't liable of anything. So today, only individuals are criminal liable, but the legal entities have civil and administrative sanctions as well. So this is what changed from before the anti-Brazilian corruption law to now. So this legislation also introduced the compliance programs in Brazil. Before 2013, only multi and transnational companies had compliance or know what a compliance program is. So the compliance programs appears in this law because it established that only companies with compliance programs can be mitigated sanctions. So have a compliance program is a way to mitigate the sanctions that the legal entities could be subject to. So the existence of internal mechanisms and procedures of integrity, audit, and incentive for the reporting of irregularities, as well as the effective enforcement of codes of ethics and of conduct with scope of the legal entity. So this reduces the sanctions. So to reduce, they demonstrate that there is a compliance program and more, and this is important. The compliance program has to be effective. So to inform what is an effective compliance program, a decree was elaborated. So this decree regulated the Brazilian anti-corruption law and established some standards, some requirements to evaluate what is an effective compliance program. So we can say the commitment of the legal entities, senior management, including board members, the clear and unequivocal support to the program, the standards of conduct, code of ethics, policies, and integrity procedures that are applied to all employees and administrators, regardless of their position of role. And this, the same is applied to third parties, such as suppliers, service providers, intermediaries, and other associates. The periodic training of the integrity program, the accounting records that precisely and completely reflect the transactions of the legal entity, the disciplinary measures enforced against those found to have violated the integrity program, the procedures that assure the immediate suspension of irregularities or detected infractions, and the timely remediation of the damage caused, the continuous monitoring of the integrity program. It is integrity program because the compliance programs in Brazil for this law, it is called integrity programs. We don't have in our legislation the term compliance program. We have the term integrity program. So because this decree talk all the time about monitoring of the integrity program and the transparency surrounding donations to candidates and political parties made by the legal entity. This last requirement is the most important because our context, the relationships between public and private spheres in Brazil, it is always surrounded by political parties and political power. So I won't read all the requirements, of course, but I don't think there is anything new in there. The main idea is a transparency, independent, and ethical program. So in 2014, 1 year later, the car wash operation was born, if we can say that. It is a federal investigation, a huge investigation, responsible for arrest more than 200 people, including politicians, company CEOs, people working in private and public sectors. And what started with Petrobras investigations become bigger and bigger and involved other countries, mostly when the company Odebrecht was investigated. So I can say that is a multinational operation because it's not only about Brazil, it's not in Brazil, but we have people being investigated in Peru, Venezuela, and it is almost Latin American operation. So, and this only happened because the anti-corruption law was elaborated. This legislation made possible to impose sanctions to the legal entities. So the investigation becoming bigger. A lot of money already returning to our public safes, but more of them still there and probably will never return. So in October 2020, we were in our 77 phases of investigations. So we have seven phases of investigations. All these investigations, these phases of investigations, has a peculiar name. So according to the situation that the investigation exposed, the federal police responsible for these investigations named the phases. So all our creativity is in the name of these phases of investigations. And I could talk more about the car wash investigation that has this name because car washing companies was used to money laundering. So today is more than this. I also talk about other political implications that car wash operators brings up, such as Dilma Rousseff's impeachment, the fact that the Sergio Moro, the judge responsible for the car wash operation, is no longer a judge. I also could debate about the fact that the car wash operation ends, the corruption ends in Brazil, and this could be a personal joke for us in Brazil, but it is a fact, it is a problematic that we have here. But the main topic here today is talk about how the anti-corruption legislation and this meaningful investigation change how Brazil deal with corruption, how Brazil deal with compliance programs. So after 2013 and the car wash operation, we realized how the corruption was endemic in Brazil. We have the first perception about this. And as you can see in this table about corruption perceptions from Transparency International, the Brazil index is lower now than it was in 2012, before our anti-corruption law. In 2015, 1 year after the car wash operation, the index dropped. We have a big drop considering the previous years. We were in 43, we were now 38, and today the last index is on 35. In 100, the perception of corruption is 35. This is indicated that the corruption perceptions in Brazil is very high. When we look these parameters that the Transparency International provide to us. And the results of this is that other countries and the society, Brazilian society, start to pressure the Brazilian companies to ensure that they are in compliance with legislation and more ethical standards. Then we had a boom of compliance programs. So we will start to hear about compliance all the time. Your company has a compliance program. Do you know what is a compliance program? Do you know what is compliance? So we start to hear about compliance all the time. All the companies, big, small companies, start to prepare to have a compliance program. So in 2018, I started to work as a compliance lawyer. I was hired to be a legal consultant and design a compliance program. And when I realized how hard is design an effective compliance program in Brazil, not because we don't have all the tools that we need, but because changing a culture is harder than we think. And talking about compliance in Brazil is talking about changing the society, changing the idea of a society, how a society think about ethics, and not just in business, but in general. So the problem is bigger than we think. And how is the compliance maturity in Brazil? The result is that the maturity of the compliance program in Brazil is low. We have a lot of companies that afford to have a compliance program, but is only in the paper. That isn't commitment with independence of the compliance officer, the transparency of the information received from the board, and sometimes it is impossible to realize a compliance investigation without any kind of company's interventions. So it's very hard to design a compliance program, an effective compliance program. And this reality is described for us as a fake compliance programs, or a compliance programs that only exist in the papers. And this kind of situations happens in several levels, small companies, big companies. If you can see in this table that I prepared, the Petrobras had compliance program when the car wash operation starts. The other branch had compliance program as well. And JATO already had a compliance program before being investigated in car wash operation. The fact is, before car wash operation, the multinational companies already had a compliance program because their relationship in the international market required that they had a compliance programs. Legislation such as UK Bribery Act and FCPA obey these companies had a compliance program. And this was intensified by Brazilian legislation. Although the compliance program exists only in the paper to a way to comply with the legislation. So the main idea of a compliance was far from ideal. So what changed? After all these scandals, the compliance companies rebuilt their compliance programs. So allocating enough money and change the business relationship. The main idea now is investing in compliance to restore the image after the scandals. And when I sent this idea of presentation, I plan just talk about it, but a lot of things changed. Today, I am no longer a compliance lawyer. I still believe in ethical standards, in compliance programs, and change our reality. But now I am in the other side of our fight against corruption, bribery, and unethical behavior. Recently, I started to work as legal advisor in the Federal Prosecutor's Office of the state of Minas Gerais, and I start to realize that our problems are more than corruption, bribery, fraud. We also had another problems. The company's commitment with our environment and human rights. And from a perspective of a compliance lawyer, I just can say that this is another challenge to our compliance system in Brazil. We don't have yet an index to evaluate how our companies are committed with sustainability, but we consider that compliance is more than corruption, bribery, fraud, and money laundering. The current information reflects that the corporation social responsibility in the companies based on Brazil is not what our society aims. And this impact on the relationship between business, local society, environment, and human rights. perhaps for the UK Bribery Act, another 10 years could be important to debate about corruption, sustainability, local implications, and human rights, and not just for the UK legislation, but consider how it can impact in other countries, but for Brazil as well. When we talk about compliance, about ethical relationship, about business, we need to be able to see all dimensions. And I think that for the next 10 years could be important. We consider business integrity as a whole. So I thank you so much for hearing me. And I finish my presentation here with my contact information. So thank you so much.
Thanks very much for that. And I just want to say, it is a pity that you weren't able to visit here again. So it was great to hear your positive words about your time studying in the UK. Unfortunately, because of the current situation with the pandemic, we're doing this online, but we will try organise a get-together for all our speakers across the different webinars at some point in the future. Our final speaker in the entire series of the webinar then is Dr. Horace Young, who is Associate Professor in Commercial Law at the University of Leicester. And prior to his appointment at Leicester, Horace taught at Exeter, Oxford and Universitas Osnabrück. He completed his undergraduate study in Hong Kong before coming to the UK for his LLM and doctorate. And Horace's research interests lie in corporate and financial laws, distinctively with a global, comparative and interdisciplinary approach. And because of this background, then he does have a keen interest to look at the experience of Asia, most notably Hong Kong, his home city. Horace, thanks very much for joining us today. It's over to you.
Thank you, Colin, for your introduction and invitation to speak in this seminar series. So I think I need to share my screen first. So hope it's working. So I'm sure now you can see my screen. So I'm going to talk about the regulation of bribery in Hong Kong. So I've always wanted to write this paper, but somehow have always delayed to start writing it. So that's why I've already done some background research, but however, I think this seminar would be a very good opportunity for me to get some feedback and suggestions before I really start to write the paper. So the reason why I think Hong Kong is an interesting example is because Hong Kong used to be a British colony, but however, in 1997, so its sovereignty was returned to China. And then in the past decade, so you may have witnessed different social events or problems that you may see in the newspaper. So, for example, in 2014, so we had the occupation of Central. So Central is the financial district of Hong Kong. So the umbrella of revolution. So a group of people occupied the financial district. So in order to protest the political movement, because they were promised different for example, the rights to elect the chief executive or the rights to elect a legislator in the basic law. However, so these promises were not fulfilled. So that's why we had the umbrella revolution in 2014. And then in the last year, so again, there was a very serious protest going on different parts of the city in Hong Kong because of the anti-extradition bill. And then also in this year, again, we had a problem in Hong Kong because of the introduction of the national security law. So because of all this political and social instability, so people are starting to feel that rather than a one country, two systems ideology as a promise in the basic law of Hong Kong, now in Hong Kong, we are moving towards one country, one system. So rather than a distinctive city or region of China. So we are actually integrating into the whole system of China. So rather than we have a system of our own in Hong Kong. So I would say the perception is, so Hong Kong has been doing quite well in terms of controlling corruption. So together with Singapore, so Hong Kong and Singapore, we are regarded as some very successful examples in Asia in controlling corruption. So you can see the footnote here. So it's based on a literature by Kra in 1994. So again, I think to show that Hong Kong has been doing quite well, so as already done by Luana, so we may want to refer to the Corruption Perception Index, so by the Transparency International. So you can see Hong Kong is still doing quite well. So according to the recent index, so it was ranked 16th out of 180 countries. So we maybe, I think it's good to compare its position. So with the point of return of sovereignty in 1997. So actually, Hong Kong is doing better than the position in 1997. So to also, I think, to compare with the position of China. So in the index of 2019, so China was ranked 80th, 80 out of 180 countries. So you can see that in terms of controlling corruption, so it's of little doubt that Hong Kong is doing better than China. And then other than external recognition, I think to get a sense of the prevalence of corruption in Hong Kong, I think it is also important to look at what the ordinary citizens in Hong Kong think about it. So you can see, so these are the data taken from the University of Hong Kong Public Opinion Program. So the better the marks, then the better the situation in terms of the controlling of corruption. So you can see in the beginning of the Hanover in 1997, so the perception rating was around 7. And then so it goes up and down throughout the year. So, and then up to the point of around 2011, 2012, actually, people were very happy. So in 2011 and 2012, so people were quite happy about the situation of Hong Kong in controlling corruption. So the index, so the rating has reached its record high to around 7.4. However, as you can see from the end of the timeline, so nowadays, so you can see people of Hong Kong are not too happy with how the government or the city has done in controlling corruption. So in 2016, so it has reached, so the approval rating has reached a low point of around 6 only. So you can see that, so there might be some problems in Hong Kong regarding anti-corruption, anti-bribery. So in terms of the regulatory structure of Hong Kong in controlling corruption, so the legislation was the Prevention of Bribery Ordinance. However, rather than the law, I think one important strength of this regulatory structure was the regulator, the institution enforcing the law, so which is the ICAC, Independent Commission Against Corruption. So one point that I would like to point out would be, so before the establishment of ICAC, so corruption was widespread in Hong Kong. So I have written down some examples here, especially in relation to the police force. So Peter Grobler, so a chief police superintendent, so was believed to control access of 4.3 million in 1973. And then also another even more notable example would be a Chinese detective called Lui Lok. His nickname was the Hong Kong dollars 500 million sergeant. So you can see how widespread was the problem before the establishment of ICAC. So I can say the regulatory structure before and after the Hanover actually is largely the same. So because as recognized by the Basic Law of Hong Kong, Article 57, So ICAC remains responsible for controlling corruption in Hong Kong, and then it remains accountable to the chief executive only. So before the handover, of course, then ICAC was accountable and was able to directly report to the governor, but now we have the chief executive. So, and then the reason why ICAC has all these powers because of the legislation other than the Prevention of the Bribery Act. So the legislation responsible for empowering ICAC is the ICAC Ordinance. And then other than the Prevention of the Bribery Ordinance, so it actually has a very long history. So the current legislation remains largely the one first enacted in 1971. So, and then other than the Prevention of Bribery Ordinance, so ICAC is also responsible for enforcing the Elections Corrupt and Illegal Conduct Ordinance. And then, but however, of course, my focus is on the Prevention of Bribery Ordinance, so which is the main legislation in controlling corruption in Hong Kong. So it's about both the public sector and also the private sector. So it gives the ICAC, the regulator, different powers to conduct their investigation. So they can search bank accounts and then to try to retrieve different documents from different parties, and then to require the suspects to report on their financial situation. So, and then also the ICAC have the power to detain travel documents, and then to also to freeze the access of the suspects. And then also all the investigation can be kept confidential. So under the Prevention of Bribery Act on Prevention of Bribery Ordinance, as well as the ICAC Ordinance. So to look at the enforcement situation, I think it may be useful to refer to some statistics. So I think one way to consider enforcement will be to look at the input and the output of the regulator. So in terms of the input, so I can say, so there is a reasonable increase of budget, so to be put on ICAC throughout the year. From year 2000, you can see the annual budget of ICAC was around 700 million Hong Kong dollars. And then in last 2 years or so, so it has increased to close to 1 billion Hong Kong dollar. So you can see that the Hong Kong government has still put adequate resources into the work of ICAC, despite now you can see the perception of the Hong Kong citizens that actually the corruption situation has gone worse. So after more than 2 decades since the handover. So other than input, we may also want to look at the output. So I think some data that I have retrieved from the annual report of the ICAC would be the number of complaints filed to ICAC. So in last year, 2019, you can see in that year, so slightly over than 2,000 of complaints were filed to ICAC. So, but however, as a contrast, so to compare the figure to the ones in 1997, right before the handover, you can see in that year, so the number of complaints were around 3,000. Of course, I think it might be difficult to interpret the data. So a decrease of complaints from 1997 to 2019 may represent really, I think the situation has improved, that we don't have serious concern of corruption. But on the other hand, I think a possible situation would be, so people may have lost faith in the ICAC. Therefore, they are not too keen to report cases to ICAC because it may actually get you nowhere. I think that actually might be more likely the reason, unfortunately, because if you look at the cases of corruption in Hong Kong, I think there are different notable cases involving some senior figures in the Hong Kong government. I think that may provide an explanation why. So if we look back to the perception of the degree of corruption in Hong Kong by ordinary citizens in Hong Kong. So I think the reason why you could see the drop will be, for example, in 2017. So the chief executive of Hong Kong, Donald Tsang, was convicted of corruption. So he has, for example, failed to declare conflict of interest, and then try to rent a luxury flat from a mainland China businessman with a very low rent or even for free. And then also you can see in this 2017 case, so Sir Donald Tsang was convicted of corruption, and then he was sentenced a jail term of 1 year. And then also together with Donald Tsang, so his second in charge, so the chief secretary, Waffle Hui, actually was also jailed, so was also put into prison a few years earlier, so in 2014, because of bribery. So he has received bribe from a property tycoon in Hong Kong. And then also after Donald Tsang has stepped down, so the successor was C.Y. Leung. Again, he was plagued by some corruption allegations. So in 2014, so it was reported in the news that he has an agreement with a Australian firm, UGL Limited, in relation to the takeover of DTZ, so a very famous surveying company. So it was essentially established because after the merger, so it's now called DTZ. But however, one of the companies, so forming DTZ nowadays, was actually established by C.Y. Leung. So as a part of the deal, so even though despite that at that time, so he has already taken the office of chief executive. But however, so he was able to receive 50 million Hong Kong dollars as part of the deal. So as a result, there might be some conflict of interest concern arising. So, but however, after an investigation by the ICAC and also after some serious consideration by the Department of Justice of Hong Kong, so at the end, they decided that they did not want to press charge on the corruption allegation by C.Y. Leung. And then also another explanation why Hong Kong people has lost faith in ICAC is because the regulator itself has faced different scandals in the past few years. I think one notable example of such scandal would be, for example, Timothy Tong, so which was the commissioner of ICAC. So he was accused of using public funds for some lavish activities, overseas trips, and then also he was alleged to have received different gifts, so from people in China. But at the end, so no charge was pressed on Tong. And then also another scandal involving ICAC would be, so Rebecca Lee, who used to be the deputy chief of ICAC, suddenly resigned from her position in 2016. Of course, I don't want to speculate on the reason why Rebecca has resigned. But however, at least I think it was widely reported in the news in Hong Kong at that time, and then therefore leading to a dent in confidence of how effective ICAC has become. So I think another evidence of people losing confidence in ICAC would be, as you can see from this picture here. So when I go to those different discussion forums in Hong Kong, so whenever people talk about ICAC, those netizens would be quite keen to post this picture. So as a joke to say that now ICAC has closed down. So if you can read Chinese, you can see all the signs there actually are saying to let. So this is a joke from them saying that so effectively ICAC has closed down. So it's no longer relevant. And then also, other than a joke by those netizens, so a similar concern has also been expressed by the Time magazine. So you can see a story in 2016 from the Time magazine. So the magazine has also expressed a doubt regarding whether ICAC is still an effective regulator. So to really conclude, so I can say that, so even though after the handover, but the institutional and regulatory structure of anti-corruption in Hong Kong is still largely the one that the city has inherited from its colonial days. So this structure has proved to work well. And then, as I say, so it still largely remain in place even after the handover. But however, as I have already said to you, so despite ICAC was once a very highly respected and fearsome institution, but now, unfortunately, it has somewhat become a laughing stock to some people in Hong Kong. So I think the problem would be, so what exactly has gone wrong? So I think if I need to make a explanation, possibly I think it might be due to the handover. So Hong Kong is more becoming part of China. So it has received a lot of influence from China, both politically and also culturally. So politically, I think one speculation of the reason why Rebecca Lee has resigned is because she has resisted an investigation into the bribery allegation of CY Leung. So faced with different pressures, so unfortunately, she has chosen to resign. And then also in terms of culture, so apparently the practices of some bribery practices are actually quite widespread and accepted in China. So apparently and unfortunately, it may be the same case now because the dealings with between Hong Kong and China are even more closer and more often. So somehow I think such a problematic business practices may have actually spread to Hong Kong. But however, I think this is my initial feelings and predictions of the reason why Hong Kong is no longer regarded as a corruption-free place. So, but hopefully, I think if I do more work on my paper, then hopefully I will be able to provide a more possible explanation of the fall of Hong Kong in relation to bribery control. I think that's it I want to say today. So thank you so much.
Thanks very much, Horace, and thanks to all our speakers tonight. I thought that was a really fascinating session, hearing about, well, we can see obviously the reach of bribery and anti-bribery efforts and different regulatory approaches or different law enforcement strategies to tackle corruption. And we really then start to see issues relating to the impact on the ground, the impact in reality. I think that did shine through in relation to all of the presentations this evening. I thought that was really interesting. But we also see issues about effectiveness. So in Kuwait, for example, we see about the effectiveness of the legislation, but in Brazil it was effectiveness of compliance programs. And how that then can lead to issues of perception, because of course, as there are anti-bribery efforts taking place, people see more of this. They see the high-profile investigations, the arrests, for example, and that might lead them to think, well, corruption is a bigger problem here, so it might be counterintuitive. Perceptions of corruption might be going up, even though efforts are underway. And so again, thank you all for really fascinating talks. And I am conscious of time, but if I can, I have 2 pages of notes from the last 90 minutes. Could I impose and ask just a couple of questions? And one of the issues, and actually, Horace, if I could bring you in again here, and also Luana, but if I start with Horace, just towards the end, you were talking about ICAC and issues of their effectiveness, whether there is outside interference or they are moving towards China. And is there any, or do you have any thoughts there on what might be done to restore ICSC back to its former glory, to really kind of have an impact in terms of tackling bribery. And Luana, similar there in the Brazilian context, are there many instances of political or judicial interference with investigations? So are there any particular obstacles or hurdles with enforcing the new law? So Horace, if we come to you first.
I think a very pessimistic view would be, so there's no turning back. So because when we move to a one country, one system ideology, then of course Hong Kong is slowly becoming a city of China. So rather than have a distinctive identity of its own. So I think the only way, if I need to try to make a prediction, will be to see whether the controlling corruption efforts in China will improve. So because now it's one country, one system, so I think that would depend on whether China can introduce some more successful efforts and measures to control corruption. In that case, I believe this will benefit Hong Kong as well.
Thanks, Horace.
And what can I say? Because the situation in Brazil is more complex than we think. It is not just enforce the law, or it's not just to try to improve the law and the mechanisms, because I think that we need to change is inside in our culture. I think that could be harder than we think, because when the car washing operation starts, we have a change it. But what we think that will be a good change with a law, it starts to be something used by the political power to put another agenda inside. So sometimes you have this here. We have a legislation to change something, and this legislation goes to try to another thing. And why I'm saying this? Because the fight against corruption established by this law made some political arrangements. So was used, the corruption fight was used to change the political power. So we have more than, I think that if I try to answer that question, is that I believe that the companies, the private sectors could be more effective in trying to make a real change. They could be more ethical in their relationships. Because I think that when they give a good example, all the structures could be in the same directions. So, and this time, in this side of the perception of the things, I think that the commitment of the private sector with the anti-corruption law could be vital to change what we have. I don't think that we need to change our law, or because this won't be, don't have any reflect. We need to change the relationships, how we was engaged with these efforts. And this is for private and public sectors. And I think that could be an answer, because the things here is more complex than this. I could explain more, because we have a political power is with strained relationships with the private sectors, and this damage everything. So a short answer could be this.
Thanks very much for that. I think it's a very important point, and that extends beyond Brazil, because it's not always an issue of, well, we need to do more to tackle corruption, so we need to change the laws. often not an issue of the law at all. So it's an issue of, for example, how you enforce the law, or as you rightly mentioned there, issue of ethics and getting this shift in mentality or perception. So thanks very much for that. Khalid, could I bring you in on this point as well about politics is as well? So are there any issues in relation to, so you mentioned about the need for modernisation, and you agreed with that there is a need for modernisation. What has the government reaction been in that regard? So in relation to suggested reforms, but also, you mentioned about corporate criminal liability, and it was a fragmented legal framework, and you spoke about the shift in approach from retribution to deterrence, the proactive and preventive approach. And it reminded me of the regulatory pyramid from Ayers and Braithwaite. And I was just wondering, do we see much of that in Kuwait? Because you talk specifically in the context of grand corruption. So are there difficulties then in responding to grand corruption with corporate criminal liability laws, for example, or modernising the laws when the people you're targeting are in charge of the laws, allegedly?
Yeah, I will start with the criminal liability of corporation, or corporate criminal liability. I would confirm that we as a civil law, we have civil law system, which kind of resist establishing the criminal liability of corporation for historical reasons. In Kuwait, we have some scattered laws that establish the criminal liability of corporation individually. So in one legislation, there is one provision that establish vicarious criminal liability. So there's a piecemeal development of criminal liability in Kuwait. And this is understandable because of two reasons. The first is, as I said, the civil law system, and the second one is the weakness of the private sector in Kuwait. In Kuwait, we have a very, very weak private sectors. The life is, we are not communist, but the life is all about public sectors because of many historical reasons that is outside of our scope. So we don't have a good framework for corporate criminal liability. For the government reaction, I think we have something in common with Brazil, which she said that the case is complex. I think it's not complex. I think there are many countries in the world that share the same experience. We have the problem of grand corruption, and in Brazil, as I think, is facing grand corruption. So we have the same type of problems. The government reaction recently is good. The government is changing, and again, this is because of political reasons. This needs a political analysis. Maybe this will take us away from our topic, but government reaction is good. But there is a very interesting point in this regard. We lack or we are not familiar with the recent developments in other jurisdictions, especially developed jurisdiction, and this is predictable. We live in a kind of isolated place in the world. I mean by isolation of the kind that we live in a rich country that does not need any legal developments in this. We can arrange our stuff with money, but lately things are different because of surrounding political climate and so on. So there are some good indications that the government will respond actively and effectively. For the permanent enforcement permanent by breath, weight, and iris, I talked about that in my thesis, and I can again confirm that enforcement permanent is too developed approach to be applied in Kuwait. We do not have clear boundaries between how can we respond criminally, civilly, or respond by like persuasion or persuasive measures. So there is or we can talk about enforcement permanent in Kuwait the way that you think. So this is a very brief response. Sorry. Yeah.
Nice, Khalid. And for anyone interested in learning more about corruption in the Middle East, they just have to wait until March and they can buy your new book when it is published. Lilith, can I come to you next? I'm conscious of time, but I really enjoyed your talk, and it actually got me thinking about a completely different area altogether. So thinking specifically about proceeds of crime, to some work that I do. And as you were talking about the appropriate standard or staying of proceedings, I had so many different questions, and I rarely think about arbitration at all. But I want to read your PhD based on what you have said here tonight. But can I just get your thoughts in relation to these two things? So about the appropriate standard of proof. And you spoke about the ongoing uncertainty in this area, about the red flags or the increased standard of proof. So my question, pretty straightforward question, what do you think is the best way forward in relation to the standard of proof? And a separate question is your thoughts about this idea of using the possibility of staying or resisting an application to stay while a criminal proceeding is ongoing as a tactic or a strategy as part of discussions to settlement, for example, before arbitration.
Yes, thanks very much, Colin. That is true. To answer to your first question, well, in my own opinion, the standard of proof in arbitration for corruption shall not be beyond reasonable doubt. So it should not be the same as for crimes, mostly because arbitrators, they do not have the same powers as judges do. So they cannot order the parties to produce the range of the documentation or to cooperate with the arbitral tribunals to the same extent that judges do, and therefore that reduces the possibility itself of uncovering any evidence whatsoever, and this presents a risk that the parties would choose arbitration over litigation in order to make sure that the corruption goes uncovered, because they would know that the standard of proof is the same. Arbitrators have less powers to uncover corruption, and then why not to go and to litigate to have a dispute be resolved in arbitration instead of going to court. And therefore the standard needs to be lower. So it might be higher than for civil cases, so it might be higher than bounds of probabilities, but lower than beyond reasonable doubt. So I believe that there should be a new standard to be elaborated just for corruption cases, because having the standard too low, again, this would also present a risk so that any sort of claim could be literally can be cancelled just because based on the approximate, or dubious corruption allegations, which might or might not have happened. And again, the arbitrators do not have enough time. And arbitration is one of the advantages of arbitration is time and resource efficiency. And make it another court-like proceedings is not efficient. If arbitrators think that they don't have enough resources to investigate it properly, they should refer themselves the matter to courts. But I believe that the new standard need to be elaborated for arbitration. And some of the cases cases, they have been that where arbitrators, they do tend to think along these lines, so that, you know, they that's why they use the formula of they had to be sufficiently convinced. No one actually has defined what that means, but the arbitrators need to be convinced that the corruption took place. So that's the first question. But secondly, indeed, that's what have been one of the famous guerrilla tactics in arbitration, just to, especially in the investor-state proceedings, for the state to start some sort of investigation, prosecution in the country, just to show that you know, there is an investigation ongoing, and to either to stop the proceedings, the arbitration proceedings, or to show that they should be released or exempt from any sort of liability in this case, because there are ongoing criminal proceedings. And very often these proceedings, they end in no reparation at all. So they wait, and the state itself would wait until for arbitration to finish, for example, and then to swipe it all under the carpet. So it works both ways. So there are advantages and disadvantages to both approaches. And again, I believe in golden middle. I believe in finding some special rules for corruption arbitration, but this might not be widely shared approach yet. So no international consensus so far, but indeed there is a risk that this can be used for tactical purposes.
Thanks, Lewis. And all that is left for me to do now at this stage is to bring tonight's webinar to a close, and that brings the webinar series to a close. So many thanks to all of you tonight, so our 4 different speakers, for a fascinating discussion. I really enjoyed it. I certainly learned a lot, and it does give a lot of food for thought, because we often focus too much on the UK Bribery Act in its own silo. We often give little consideration to anti-bribery efforts elsewhere, so it is very refreshing to hear about such efforts in different countries, in different areas. And as I said, that does bring the series to a close. We had 5 fascinating weeks of discussions on different aspects of anti-bribery. It was mentioned earlier that this series was originally designed as a one-day in-person conference to launch the FinReg Research Centre at IALS, but of course, due to the pandemic, we were unable to meet in person. And I'm really thankful to all of our speakers who kindly agreed to deliver their talks online instead. And it has allowed us to launch FinReg and to reach people in places that we would not otherwise have been able to, or people that would not otherwise have been able to attend here in person. So a final thank you to today's speakers and to our speakers from the previous 4 weeks for such a fascinating, really insightful discussion of anti-bribery. So thank you all for that, and we will finish up there.